Appeals Division 1 is now in session.
Please be seated. Court now calls case number CV14103, Marcia Ann Bonafide versus Gary Giangelo. I tried as best I could. This is the time set for oral argument. Counsel, let me advise you or remind you that these proceedings are being audio and video recorded, and a few days after we have this oral argument, the argument will be downloaded or uploaded to the court's website, so I want you to be aware of that. Each side has 20 minutes to present your argument. Counsel for the appellant, you can reserve time for rebuttal. As you know, we've reviewed everything in this case. We've reviewed the briefs. We've conferenced the case, so we're very familiar with the issues. You have a clock on the podium to keep track of time. And counsel for the appellant, you may proceed. And Mr. Workin?
Yes, Your Honor. Thank you. Good morning, Your Honors. My name is Charles Workin, and I represent the appellant, Marcia Bonafide, in this case. Normally, Your Honors, I would not present 5 issues on appeal, but there are so many things wrong with the decision in this case and with the bases for the decision that I had to do so. First and foremost, Your Honors, there was no substantial and continuing change in circumstances that would justify a modification of spousal maintenance. The husbands, and I'm going to use that reference rather than call him by his first name or struggle with the multisyllabic last name. The husband's retirement was not a substantial change. He had effectively retired, as he admitted himself, before the decree was entered a year before, and he kept paying spousal maintenance at the agreed-upon rate of $1,800 a month for, I believe, some 6 years before he petitioned for reduction. Likewise, his mother's death and the end of her subsidy of his maintenance payments was not a substantial and continuing change in circumstances. While it was continuing, it was not substantial. He inherited...
Financially substantial is essentially what you're saying.
Yes,
Okay.
yes. He inherited her estate, or at least the bulk of it. Arguably, he gave away $100,000 to his brother, but he inherited at least $360,000, the income from which by itself is greater than and more than offsets the $500 subsidy or contribution that mom was making towards his maintenance payments. But moreover, he had the corpus. He had all of her estate. So for those reasons, there was not a substantial change in his circumstances that would justify a reduction in his maintenance obligation. Beyond that, there are multiple findings of fact that were made here that are relevant to the statutory factors, the factors listed in 25-319, that are clearly erroneous. Not the least of which is the trial judge's reference to and reliance upon husband's expenses at, as stated, the judge thought, in a 2004 or a dissolution trial time period affidavit of financial information of something like $3,600. But that number can't even be found in that AFI. Yes, Your Honor.
Let me ask you a question, counsel. How much time did you have for the hearing?
Not enough time. I wasn't counsel at the court.
In looking at the record, how much time did trial counsel have?
I think they had a total of 2 hours to split between them. And I think that the shortage of time was an issue even before the hearing began. We decided not to make that an issue here because these other arguments are themselves decisive.
Is some of what you're raising, though, on appeal things that your client didn't get to address at the trial? I read in the briefs, and I got the sense that maybe she wanted to testify or rebut certain issues, and she ran out of time.
Yes, I believe that's correct. There was also a focus on whether husband had greater assets. That was suspected back at the time of the divorce. and there was this sort of reservation clause in the decree that was interpreted differently by the parties. Marcia believed it allowed her to go back and explore whether he had greater assets than he was acknowledging, and that was some of the focus in the in the discovery prior to this modification hearing, and there wasn't really. Some time was spent on that at the modification hearing, Judge.
Exactly how much money the husband inherited was disputed and litigated?
Oh, no, the amount of the inheritance was not disputed, no. That was in the neighborhood of $460,000. I think we have a chart of the amounts in the accounts in the brief.
I guess you're right. I am thinking about the affidavits that were attached that talked about maybe some of the money had been dissipated before.
Well, back at the time of the divorce, there was some belief that he was secreting money. He had cashier's checks sitting in a drawer or a closet or something of that sort at home.
I'm sorry, I don't want to get you off on that tangent. That's really not our issue on appeal.
All right.
But, so, the inheritance is do you take issue with the findings by the trial court regarding the amount of the inheritance?
I don't think there's any dispute about that, and I don't think there was a finding made. The only exception I would take, Your Honor, is that there
was a finding. It says total inheritance for respondent on page 3, $358,976.41. Are you taking issue with that?
No.
Okay.
No. As I was about to say, the only issue I would take with it is that the court, although the court acknowledged that husband shared $100,000, the actual inheritance was $460 in round numbers. Brother shared $100,000 with his brother, and we believe that that was done voluntarily. That there was the accounts weren't titled in a way that required him to do that. He gifted $100,000, and so we thought that husband ought to be considered to have had $460 when considering his financial resources for purposes of making the spousal maintenance award.
And that fund was his to disperse how he wished.
Of course it was. Of course. But if he were to do so and to then jeopardize or undermine his own ability to pay spousal maintenance, that doesn't entitle him to a reduction in maintenance.
Let me ask you a question. Now, there's the husband's expert, and he opined that basically husband couldn't pay more than $577 a month to have enough money to last a reasonable amount of time during his later years. I know one of the arguments you make on appeal that you assert as an error are the income figures and the expense figures that are relied upon by the court.
They are in error, yes.
And I think that's conceded, that those numbers are wrong.
I think so.
Are those the same numbers that the expert used in his calculation? I couldn't determine
No,
that.
I think the expert was using the amount of the inheritance and perhaps also his Social Security income in forming an opinion as to how much he could afford to pay over a period of time, taking him to some advanced age.
So the point that's made by a wife or appellee is even if the court...
Wife is
I'm sorry.
appellant.
Husband.
Sorry.
Is that even if these income figures used by the court are wrong, it doesn't matter because the court's reduction of spousal maintenance is based on this figure of $577 a month and the inheritance. So even if the court had the wrong income and expense figures, that isn't the primary finding upon which the court based the reduction. How do you respond to that?
Well, it does matter because the expert only considered the husband's ability to pay. And that's only one of the many statutory factors. And as it turns out, the expert's opinion wasn't determinative. The court did not rely on that or wholly rely on it because the amount of the award was $700, not $577. And we don't know how the court got to $700. There is no arithmetical basis in this record, in this decision. And given these findings, one cannot connect the dots and understand how the court came up with 700, because the court, frankly, using wrong numbers and a failure to consider all of the relevant statutory factors, reached a decision that just is not supported by this record. The court was too focused on the income of the parties and not sufficiently focused on all of the relevant statutory factors. And a major factor here is the relative financial resources of these parties. Husband has, as everyone admits, at least $360,000 plus his income. Wife has little or nothing plus her meager Social Security income, and she's disabled and unable to work, and he's retired.
There was, and I think it's challenged, an issue about whether or not she's helping her mother or she's got income from a daughter. I see those came in through husband's
Proposed findings of fact.
proposed findings of fact.
Yes.
But I didn't see that, at least prior to the motion for new trial, that they were ever flushed out in any way.
There is no evidence or stipulated fact or anything to support those proposed findings. And therefore, to the extent that the judge, who apparently relied on those proposed findings, did so, they are clearly erroneous.
And there wasn't anything in the record prior to the hearing that would have supported those?
No, Your Honor, not, and
I didn't see anything.
and I've been through this record from day one. But yeah, I would suggest to you that her affidavit of financial information was uncontroverted. What she says her income was, what she says her expenses are, was not disproven. Then there is no basis really to question it. Questions were raised about whether she had somehow inflated her expenses because she was paying for mom's share of living at the same house, and whether she also had income from renting out another house, but those things were never proven. And I believe at one point in the decision, His Honor actually agreed that there was no evidence of the unreported income. I'm sorry, I don't see that immediately in his multi-page decision. But so, as I've already alluded, the findings of fact are really insufficient as a matter of law because, as I said, you cannot connect the dots and know how the court arrived at that amount. And then beyond that, the reduction from 1,800 to 700 is simply an abuse of discretion where the court fails to consider all the statutory factors and concentrated as it did on the husband's ability to meet his own needs without really considering wife's inability to meet her needs. So for those reasons, because there is no substantial change in circumstances, this decision should be reversed and simply remanded to the court with instructions to reinstate the previous amount of child support. Spousal maintenance. But alternatively, that is the conclusion that should follow from my first argument. From the second, third, and fourth arguments, the alternative would be to reverse and remand for a new hearing. But in any event, and even if you were to affirm this, the court abused its discretion in denying her attorney's fees. The court simply failed to consider the relative financial resources of the parties in denying fees and focused only on their comparative incomes, and his income is 3 times that of hers. She simply cannot afford to pay fees, and she should not have had to pay fees for his petition, to oppose his petition to reduce her spousal maintenance. So in any event, that denial of fees was an abuse of discretion. Your Honor, I thought I saw another question.
No.
All right. I will reserve my remaining time for rebuttal. Thank you.
Thank you, counsel. Ms. Counters? Ms. Counters, I couldn't quite hear. What's the correct pronunciation?
Janangelo.
Janangelo? I apologize.
Oh, no
Is
problem.
your client here today?
No, he is not.
All right, I would apologize to him if he
I
was
will.
here.
It took me a while to figure it out as well, Your Honor. Good morning, Your Honors. Lisa Counters on behalf of the respondent appellee, Gary Janangelo. The trial court should affirm the lower court's decision because all of the issues raised by wife require the court to find that Judge LeClaire abused his discretion. Both parties concede that the standard of review is abuse of discretion. This court does not, in terms of the expert decision, this court doesn't substitute its judgment or its valuation of the expert's opinion for the trial court's opinion. I want to address Your Honor's question about time because I was actually trial counsel in the matter. We had 2 hours to present, and the court split it roughly equally. I had no opportunity to cross-examine Ms. Bonafide at all. And so if anybody suffered from the lack of time, I believe it was my client in terms of the facts that Your Honors refer to that are difficult to sort out from the record. But
Counsel, let me kind of jump to the issue that's of the greatest concern to me anyway.
Okay.
And that is, clearly the trial judge erred in his findings of fact regarding husband's expenses and income. He's got the wrong numbers,
that is correct, Your Honor.
and they're really way off. And so when a case comes up on appeal like this, and we're looking at determination of spousal maintenance, and we have a judge using wrong income figures that are 10 years old and expense figures that are wrong, that are way off, how do you respond to just sort of the smell test of how do you affirm a spousal maintenance with those kind of clear factual errors in it?
Because, Your Honor, the ultimate basis of the court's decision was the fact that the expert calculation based on, which was, in fact, both experts, based on accurate current AFI information. Both relied on the correct information, and both experts opined about from the correct information with respect to both parties' expenses and income. And ultimately, when you look at the court's decision, it's based on the expert testimony.
Counsel, let me ask you a question about that. I didn't see in the briefs reference to the financial information that the experts relied upon. I think the response by your opponent is it's not stated anywhere in the record. Can you point me to somewhere in the record as to the financial information?
I can, Your Honor.
Okay.
One moment, please. Both experts' reports were admitted at trial and discussed, however briefly at trial. Our experts' report was admitted as, and I apologize, when we actually got to trial, the clerk made us reverse the order of our exhibit. So the expert report from petitioner's expert was Exhibit 17, a financial profile for Gary Janangelo, and our expert's report was admitted as Exhibit 36.
But wasn't the main point of contention between the experts the amount of income that your client could expect to receive from the inheritance asset?
Correct.
And so when the trial judge says, as he did in the minute entry, that your client had Social Security income at $1,432 a month, and then said, respondent receives or will receive some income from the inheritance he received as a result of the passing of his mother. So the trial judge acknowledged that your client's income included not only Social Security, but the amount of money that he would receive from the inheritance.
That is correct.
And the judge also set forth his observations regarding the relative merits of the expert's testimony on this issue. That is the issue as to what would your client's income be each month.
That's correct.
And the bottom line for the trial judge was that allowing for a reasonable amount of income from that inheritance still puts your guy in the red,
That is correct.
especially with regard to payment of the full $1,800 monthly obligation.
Absolutely correct. And the affidavit, Your Honor, assumes that he draws the interest out every month.
I mean, you're not acknowledging, are you, that the trial judge used an incorrect income figure, are you?
No, I'm not. He used the correct income figure because he talked about it later in his findings of fact. It was.
I don't see where the trial judge gave it a dollar amount for how much he determined based on the expert's opinions as to what your client should expect. But it does look like, to me, like he considered it.
He did, Your Honor. Both my clients, AFI was admitted, and those were the figures. We estimated originally before Mr. Elsey prepared his report what income the client could expect based on what the funds had earned in the previous year. And so the trial court does, when it ultimately talks about my client's income, use the correct amount.
Well, in the trial court's discussion, in, I guess it's finding 18, he apparently rejects as over-enthusiastic the wife's expert's estimate of how much income he should expect to receive, and then seems to think that your guy was a little too pessimistic because he awarded more, as Mr. Workin explained, he awarded more in spousal maintenance than your expert was suggesting.
And I think the evidence, can I interrupt for once? I think the evidence in the record supports the upward deviation from the 577 that Mr. Elsey determined, because Mr. Elsey's practice in financial planning is to assume that his clients live to 100. So as he testified at trial, they don't come to me when they're 89 and tell me they ran out of money because I didn't plan for a longer lifetime. So the judge acknowledged that Mr. Elsey's report has my client living to age 100 and recognized that he may or may not live to age 100. And I think it's reasonable in the record to support the fact that's where the additional payment comes from in the judge's determination.
Well, the judge acknowledged that even though your guy only has even though he has $1,432 in Social Security income, that he's been meeting his obligations, and therefore he must have other income above and beyond the Social Security income.
And at that time, at the time that ultimately in 2006, my client's expenses are subsidized by his mother. The expenses the judge is speaking of there goes back to the affidavit of financial information originally filed in 2004. Where my client ended up with the bulk of the debt, which was ultimately discharged in bankruptcy.
But the trial court wrote, the court notes that respondent has been able to meet his obligations on an ongoing basis for a significant period of time. So the trial court had to have attributed value to the fact that your client had the inheritance asset.
I agree that he did. And nothing, the problem, Your Honor, is that I'm not unsympathetic to Ms. Bonafide's position, but nothing requires my client to risk being penniless at some point in support of her.
True, but on the other hand, she is entitled to fair consideration of the income stream that he could expect from that asset.
And the court and the experts credited her with that. And that's clear from the record. And to reject wife's expert, I don't think was a big stretch, because his testimony was that by the time he reached 89, my client would be earning $95,000 a year on his asset and would have $426,000 amassed at that point, even though he paid $1,800 a month spousal maintenance and continued to have expenses at the same level. I don't think that this court can find that that Judge LeClaire's rejection of that testimony is unreasonable or an abuse of discretion. And if you focus on that, and if you take the other circumstances, the other errors that were factual errors made by the trial court, the abuse of discretion language or that standard of review doesn't require that if the trial court makes an error, then it's an abuse of discretion. It requires that your honors look at the record as a whole. You can't take 2 or 3 or 4 facts in isolation and say, well, therefore the court committed an abuse of discretion, particularly when the court has a substantial amount of reasoning and analysis behind the number he ultimately selects. And I don't think that it's evident, as Mr. Workin suggests, that the court's calculation was, nobody could figure out how he reached that calculation. I think it's clear from the record that our expert testified that there would be at the 577 figure, that would give him an 80% chance of keeping his money to age 100. And the court's entitled to say, well, he's probably not going to live to 100, and she has needs that have to be met. So it's worth some risk for him to have to pay more than what the expert determined. Unlike child support, Your Honors, there's no formula for spousal maintenance. The Maricopa spousal guidelines are gone, and the cases that Mr. Workin refers to, where there's a calculation in it, are far different than this case. It's where there's nothing in the record about, in one case, there's nothing in the record about dad's expenses at all. Here, there is an analysis of the expenses. And with respect to the amount of the court's finding that wife's expenses were somewhat inflated as to her, that's a reasonable inference from the evidence that's in the record. If you look at her financial affidavit, she admits that her mother lives her and subsequently admits that she lives in a home provided to her by her brother, but that she pays rent and utilities.
Was that presented at the trial or in the motion for new trial?
The fact that she lives in a home with her mother was at trial. The fact that the home is owned by her brother was brought up in wife's post-trial motion. Obviously, if I'd had an opportunity to cross-examine her, my position is, or make an offer of proof, there was evidence in the record to support both those findings. But even based solely on the affidavit of financial information, if you add the amount she lists for A and B under number 7 in the AFI about utilities and expenses, it totals $1,233. So if she is only reflecting expenses as to her expenses, that means that between her and her mother, their monthly expenses are nearly $2,500. And that means that her mother, who earns $1,300 a month, as evidenced on the AFI, after those 2 expenses alone, only has $77 left to pay her share of other utilities and other living expenses. So it's a reasonable inference, I think, from the record that he believed her expenses were somewhat inflated as to herself just by simply looking at the affidavit of financial information. The court doesn't even have to consider the finding of fact about whether she reported income or not from money she receives from her daughter on a home that is in her name for her daughter.
Mention something. Did the court not allow you at least an offer of proof?
That is correct, Your Honor.
At the end of the trial?
At the end of the trial, I said, sorry to say, Your Honor, twice I kind of tried to say something and goes, this is an oral argument. I did make those attempts. Obviously, it wasn't our issue raised on appeal. With respect to the issue of whether the change was substantial and continuing, I think that wife's counsel looks at this in a vacuum, in a completely different matter. First of all, Gary did testify at trial that he effectively retired in 2004. He did not know in 2005, when the document was executed and the stipulated decree was executed, that he had retired. He also testified at trial that he continued to look for work, that he was actually working underemployed at the Yavapai College for $8.50 an hour, and that in fact in 2000,
What?
He was working at Yavapai College, earning $8.50 an hour at the time, and he took a position in Las Vegas consistent with the kind of work he had done previously, and that only lasted for a few weeks because his mother complained about caregiver he had arranged to and paid to take care of her. After that, they considered, was it appropriate for her to do some sort of assisted living, some sort of nursing home type of situation, and that would have cost mom over $5,000 a month, and she did not have that income. So it was, although he ultimately testifies with hindsight that he essentially didn't go back to his position in 2004, at the time of the decree, he was still looking for work and intending to not stop working or retire. And the language in the decree that triggers his ability to file for a change in spousal maintenance is that he retires and receipt of Social Security benefits. The word "and" appears in that clause. So he didn't ultimately start receiving Social Security benefits till 2008. And because he could afford to continue to pay that, because his mother was continued to subsidize his spousal maintenance payments, he ultimately didn't seek a modification until 2012. Nothing would have prevented the trial court at that point and I've had this done, attributing income to him that was essentially a gift from his mother for living expenses. There's nothing that would have stopped the trial court from doing that at that point. So the substantial and continuing change at the time Gary files his petition is the death of his mother. The death of his mother does two things. It stops, not only does it stop his subsidy of the spousal maintenance, but it also stops his payment of his living expenses. And the wife makes the point that we didn't point to the record where we'd established that mother was receiving income, and because of that mix-up at trial, I did unfortunately cite the wrong exhibit in my brief. But at Exhibit 39, it showed Gary's mother's bank records, which show continuing deposits from a civil service pension as income. So she was helping him pay from income she was receiving that ceased at the time of her death. And so the substantial change in circumstances is not only is he not getting a subsidy, but now he's forced to pay for all of his expenses on his own. And that's a substantial change in circumstances. Even if you use either of the AFIs originally filed or the one subsequently filed before trial, he's still got to make up $2,600 in individual living expenses that his mother was completely subsidizing prior to that. So that is a substantial change in circumstances from the time of the decree. The second, it makes it continuing, of course, Your Honors, because Gary's mother has passed. She will no longer receive income from annuities and her civil service pension that was used to help Gary subsidize the amount. So it is a substantial change in circumstances, and it is a continuing change in circumstances, because all that Mr. Giangelo has to live on now is his mother's inheritance. And what the court ultimately determined is that he's going to have to give some of that up to continue to pay spousal maintenance, and but he doesn't have to go broke in the process or risk running out of money in the process. With respect to the court not considering all of the statutory factors, the court considered the statutory factors that the parties raised. Many of them don't apply, but with respect to the ability for her to meet her needs, the ability for him to meet his needs, and the ability for him to pay his needs. While that was significant focus, that was really the only thing that had substantially changed at the time of the trial, is what your expenses were and how was he going to pay them. So it was an appropriate focus, and the court did consider all of the factors that were relevant to this case. So I don't think that the court erred by not articulating each and every factor, because each and every factor doesn't apply in this case. With respect to attorney's fees, Your Honor, again, that is subject to the court's wide discretion. It was Gary's petition, but Mrs. Bonafide knew that petition would be coming because they contemplated it at the time they were divorced. And while it's unfortunate, it was her choice to spend trial time and pretrial time focusing on whether Gary had secreted his mother's assets or how he and his mother had depleted her assets, not Mr. Gianangelo's choice. And the court simply, while it made factual errors, did not abuse its discretion. Thank you very much.
Mr. Workin?
Yes, Your First of all, we disagree about what the standard of review is. It is not abuse of discretion as to each and every one of these issues. And I think that's clear from the briefs. I want to clarify another point, Judge Thompson. That is that Mom died on September the 13th of 2012. This petition for modification was filed on September the 28th of the same year. So husband did not have did not inherit from mother much prior to that. Didn't inherit, of course, before she died, and wasn't paying over a period of years using the inheritance.
Right.
Okay.
But I thought your point is that up to the time that she died, he had income from her, essentially, and then after she died, he had income from his inheritance, so there was really no substantial change.
That's correct. That is correct. Maybe I misperceived or understood your question of Ms. Counters.
No, my point
Okay.
is just that to the focus seems to be on an assertion that the trial court was under the illusion that the husband only had income of $1,432 each month, and it's clear that the judge knew that he had more than that and considered it.
Well, I think you're reading between the lines, Your Honor, and this case illustrates the reason for the rule regarding findings of fact, and it illustrates why they need to be made with detail and clarity so that this court can review the decision. And as the Kelsey case makes clear, you can't uphold the decision simply because you think you can find some evidence in the record to support the decision. This isn't, of course, like the review that we would be doing if there were no findings of fact. The court was obligated to connect the dots, and this case, the court failed to do so in this case, and it's impossible, I submit, to reconstruct that.
So what you're saying is that the court needed to be able to, in its findings, lead us to how we got to the $700 a month figure.
Absolutely.
And would it be fair to assume that at least in one of the reports, the expert opined how much you could afford if you had less than 100 years? You know, the 577 was at 100. If he lived to 85, it would be X. I don't have the exhibit in front of me, but
And I don't think that range of outcomes or calculations is set forth in that report, Your Honor. I think he arrived at but a single number of 577. And before I run out of time, I also wanted to point out that I thought Ms. Counters referred to Exhibit 39 as evidencing mother's income during her life. I believe Exhibit 39 is husband's, another of husband's financial affidavits. It is not her bank statements. The bank statements that were marked were never received in evidence. So there, again, as I point out in the brief, there is no evidence of whether mom had income during lifetime other than Social Security, and if so, what the amount of that income was. Your Honor, I think with those comments, unless you have further questions, I thank you all for your consideration of this important matter.
Thank you, counsel.
You're welcome.
We'll take the matter under advisement. We'll issue a written decision in due course. Court's in recess.